Good afternoon to all participants in the online public hearing organized by the Independent Evaluation Commission for assessing the integrity of candidates for the position of member in the self-administration bodies of judges and prosecutors pursuant to Law Number 26/2022. I hereby declare this session open. This hearing involves the resumed evaluation of Mrs. Veronica Cupcea, candidate for the Superior Council of Magistracy, Judge of the Orhei District Court. I would like to welcome you, Mrs. Cupcea. We are here to conduct an online public hearing in the context of the resumed evaluation process aimed at assessing candidates for the position of the Superior Council of the Magistracy. The Commission is acting in accordance with Law Number 26/2022 and its rules of procedure. On the screen in front of you, you have the 5 members of the Commission: Victoria Henley, Nadezhda Repchevsky, Tatjana Raducanu, Nona Tsotsoria, and myself, Herman van Hebel, the Chair of the Commission. The Commission is also assisted by members of the Secretariat. The online public hearing can also be followed by representatives of the media and the public. During the hearing, interpretation between Romanian and English will be provided, and to allow for accurate interpretation, I would kindly ask you to speak clearly and slowly. Furthermore, the proceedings are being recorded, and the public parts will be available online, generally within 24 hours after the hearing, via the website of the Commission, www.vetting.md. I will start with a brief overview of the procedural background of this resumed evaluation. On 11 January 2023, the Commission issued a decision in relation to your integrity evaluation for the position of member in the Superior Council of Magistracy. In its decision, the Commission decided that it had serious doubts about your compliance with the criterion of financial and/or ethical integrity in relation to 1. Source of funds for financing 2 properties purchased by the candidate's family, the repayment of a loan contracted in 2012 and paid off in 2014, and undeclared donations from close persons in the annual declarations for 2012-2014, and the second issue, undeclared cash savings in the 2019 annual declaration and undeclared financial contributions in the 2020 annual declaration, used to pay for 3 installments of a total of 446,670 lei in 2012 for a loan of 540,000 lei in 2018. On 6 February 2023, you appealed this decision to the Supreme Court of Justice, and on 1 August 2023, the Supreme Court of Justice annulled the Commission's decision and ordered a re-evaluation. On 7 September 2023, the Commission started the resumed evaluation, and on 15 February of this year, 2024, pursuant to Article 19, Paragraph 1c of its Rules of Procedure, the Commission sent you a statement of facts and serious doubts. On 21 February 2024, you responded in writing to the statement of facts and serious doubts, and on 29 February, you informed the Commission that you wish to participate in a public hearing. During this hearing, the Commission will take into account your privacy and, where required and possible, the privacy of your family members and close persons. So we will leave out unnecessary details relating to, for example, ID numbers, bank account numbers, addresses of real estate, and the like. For the protection of your own privacy, we ask you to do the same. The present hearing takes place at your request, and the hearing will be focused on the statement of facts and serious doubts that the Commission has sent to you and your written responses to these statements of facts. I will briefly explain the procedure for today's hearing. For each issue included in the statement of facts and serious doubts, you will be given, if you so wish, a maximum of 15 minutes, 15, to briefly provide additional explanations to complement your written response to the statement of facts and serious doubts that you submitted to the Commission. One or more members of the Commission may have questions for you about the explanations you have provided, both in writing and during the hearing. I urge you to be concise in your explanations and answers. I also urge you to answer all questions truthfully and completely, and your explanations are important to the Commission in verifying your financial and ethical integrity. I would now like to hand over to Mrs. Tatiana Raducanu to lead discussions with you on the statement of facts and serious doubts. Tatiana, you have the floor.
Bună ziua, doamnă Cupcea.
Good afternoon, Madam Cupcea. Good afternoon. So I will address the serious doubts that the Commission has in relation to the source of funds for financing the two properties purchased in 2012 and with regards to the repayment of a loan taken in 2012 and paid off in 2014. And I will also address the matter of undeclared donations from close persons, donations that were not declared in the annual declarations for 2012-2014. If you would like to provide now some additional explanations to complement the answers you provided in writing regarding as in your response to the SOF, if there's anything you'd like to add. Well, in terms of anything additional to my response to the statement of facts and serious doubts, so I believe I was quite thorough and detailed, and I've provided a detailed written response to that. And additionally, I've also provided records and documents that the Commission couldn't have obtained. I mean that in the context of the resumed evaluation, the Commission has indeed sent a number of requests. It received some answers and it gathered many documents. And I too had a look at that, and I've also annexed additionally some pieces of information that the Commission couldn't have realistically obtained on its own. I wanted for this public hearing to take place because I hope that all that additional documentation that I provided, I mean the documentation that the Commission obtained and the further documentation that I submitted, well, it is my hope that these were such as to mitigate the serious doubts that the Commission had. I also wanted for the hearing to take place by referring to Article 4 of the evaluation regulation of the Commission, because Article 4 provides that it says that cooperation or lack of cooperation by a candidate in the process of evaluation may be taken into account by the Commission in order to establish if the candidate mitigated the serious doubts with regards to the observance by the candidate of the criteria of the financial and ethical integrity criteria set out in Article 8 of the Law 26. Therefore, to show that I am open towards cooperation and hoping that the fact that I cooperated, showing that I am willing to cooperate with the Commission, it's as a response or willing to show that I've asked for this hearing. However, when it comes to add anything to what I've already sent on the 21st of February to the Commission, and also considering that I've sent those records on the 21st and then on the 22nd, I think I've also sent something, and then on the 1st of March, if I'm not mistaken, I remember I've sent some other documentation. So in addition to all of that, I have nothing to add. Fine. Thank you. Now, regarding the source of funds for the purchase of the two properties in 2012 and regarding the repayment of the 2014 loan. In 2012, you acquired two properties for a total price of a bit more than 902,000 lei. During the initial evaluation, you stated that the funds used to purchase those properties in 2012 were your and your husband's cash savings from salaries, and also you claimed there were funds received from the sale of a studio apartment in Chișinău for 174,812 lei in 2011. One of the properties was paid for in two installments, 30,000 lei at the signing of the sales of purchase agreement, and then 270,000 lei 1 month later from a loan taken from one of the national commercial banks. The loan was paid off in full in 2014, the final payment being 246,000 lei. In the initial evaluation, during the initial evaluation, you told the Commission that the funds used to pay off the loan in 2014 were received from relatives and that there were also savings of your family following the increase in judge's salary in 2014. According to you, your relatives' contribution to the repayment of the loan included the sale of 4 land plots by your mother, the pension of your the pension that was of your father-in-law that was provided to your family's financial contribution, and there was financial contribution from your parents, and the contribution from a close relative of your husband, whose child you took care of between 2003 and 2008. The only documentation that you submitted in your initial evaluation regarding the repayment of loan was the loan agreement and a bank statement confirming that payments had been made and that the loan was fully reimbursed. At the hearing, in the initial evaluation, you admitted that those financial contributions received from relatives to repay the loan of 270,000 lei, that they were not received all in 2014, but in the previous years as well. During the resumed evaluation, the Commission has identified that 2 of the 4 sources appear to be irrelevant for the repayment of the loan, specifically the sale of the land plots by your mother in 2015-2016 after the loan was repaid, and then the contribution of a close relative of your husband whose child you took care of from 2003 to 2008, as this period was earlier than the year in which the loan was taken. Do you agree that those 2 sources, income from the sale of land plots and the payments for child care, they are not relevant as sources? I regard them as relevant because the contribution of the relative until 2008, that would allow us to make savings from our salary. So that was a source of savings, a possibility to save money. We were able to make some savings, and in 2012, we were able to purchase those properties, and then we were able to to collect more money to give the credit to pay the loan back in 2012, 2014. With regards to the land plots, as I have initially stated, I was not aware when exactly they had been sold. However, as I've been saying since 1987, when I left the home where I grew up, and until 2017, when my mother passed away, all that period of time I was being financially supported. She would help me by giving me financial resources, and I provided evidence of that. There were certificates and pieces of evidence showing that she had income, allowing her to secure that financial support for us. I understand, but I mean the land plots now. They were sold in 2015 and 2016. That is after the loan had been repaid. Right, because I was paying for it on the basis of the agricultural produce that we were collecting from those land plots. The fact that the land plots were there was granting the bigger income that she could share with us. In 2016, when the land plots were sold, the income diminished. She would only sell agricultural produce from the land adjacent to the house. But until 2015 and 2016, respectively, the years when the land plots were sold, until that moment, we were collecting the crops, the agricultural produce. I provided documentation as to that and pictures when we were going out there working the farmland. And our mother was as if paying for our work. We were helping her out, and considering the crops we would collect, she would help us. After 2016, the income diminished a little bit, but in that period of time specifically, we would harvest the crops, we would sell it, and thus our mother had a possibility to help us too. The increased income from the salary payments in the amount of 61,000 was confirmed, as well as the pension that you referred to, starting with 2009. The total amount was 143,181 lei before 2013. In your answers to the statement of facts and serious doubts, you provide additional documents and explanations that you hadn't provided before to confirm specifically the capacity of the close persons to provide you with the contributions that were used for the repayment of the loan in 2014. The additional evidence regarding the sources of funds of your close persons that you referred to are the following: income from the sale of a bicycle and from the sale of a car Moskvich, the salary of your mother-in-law, who continued to work after she retired. The other one is ownership of 3 hectares of land on which there was a walnut orchard that generated additional income for your parents-in-law. Income from the sale of household goods after the death of your father-in-law. Dividends from proprietary funds invested by your mother and your parents-in-law, and your family's cash savings from 2013. A question now. Please confirm that you have submitted additional documents during the resumed evaluation that you did not provide before, and you've provided them now as a response to the statement of facts and serious doubts. Do you confirm this? Yes, I confirm that I submitted a lot of documents. Can you explain why you did not submit the documents during the initial evaluation? What kept you away from doing it at that time? I did not know that this would lead to serious doubts. It didn't cross my mind. I have never even thought that about the fact that this could lead to any doubts whatsoever. I didn't even think that my statements would be doubted. I didn't think it would turn out like this, so I thought that my explanations were rather credible. Well, I didn't know. I'd say that this is quite a novel, a new procedure for Moldova, not only for me, so I did not expect things to go like this. Please explain how the additional documents and explanations provided by you during the resumed evaluation, how do they explain the source of funds of your relatives for the purchase of those properties in 2012 and for the repayment of the loan in 2014? I think I didn't understand the question. What do you mean? So the documentation that you provided, the explanations that you provided, how do they explain the source of the funds? Well, they had income. So this income, do you confirm this income from the sale of the bicycle, these proceeds from the sale of the bicycle and all of that? Do you confirm that? Well, yes, I provided documentation confirming those sources. There is an even from the court, I provided a document from the court, a sentence where my mother was the injured party, and she referred to the assets and the money that was sold, that was stolen, sorry. And having read the sentence, I've remembered even about the bicycle, because tens of years had passed, and I didn't remember. The bicycle was stolen, the bicycle was given back, and then my mother sold it. And even if this was written in the sentence, I remember my mother was saying that she had sold it back to the person who the thieves actually initially gave it to. So the thieves stole the bicycle and gave it to some people, and then my mother sold it to those people. And then the father of the child who got the bicycle, and the case was closed, but the father of the child talked to my mother. He said that his child liked the bicycle and he would like to have it. So that I recalled by reading the sentence, because I didn't remember the details otherwise. So, but you also talked about the salary of the mother-in-law who continued to work after retirement. So the mother-in-law would receive a pension and a salary. Yes, she used to work as a teacher. In that settlement where they lived, they didn't have a teacher of biology and chemistry. And in the beginning of the year, or at some point of the school year, so at the end of August, they asked her to continue to work. So they would conclude a work agreement for another year, and and then she kept working like that for many years. What about the 3 hectares of orchard, walnut orchard? I mean, what was that? Well, that belonged to my father-in-law, sorry, and he planted walnut trees there. So there was farmland, his share of land, so to speak, and he planted walnut trees there. It was about half a hectare, I can't remember, there was half a hectare of grape, so a vineyard, and they've planted Isabel variety back in the 1980s. So that was his farmland he got. What was his income out of walnut and the vineyard? I've annexed a certificate from the local public administration, and there they confirmed, they indicated that for 1 hectare Isabella variety, there will be 8 to 10 tons of grapes a year, considering the vineyard, the size of the vineyard that they had. Well, given that if they had about, there was almost half a hectare, 0.45 to be more precise, that was covered with vineyard. They were not using about 4 or 5 tons of grapes a year. They would sell that. I mean, a family, that would be too much for one household to use that many grapes. So every autumn they would sell the grapes. Additionally, there's a confirmation from the public administration, local public administration, the agriculture department, 1 hectare of walnut orchard starts yielding produce in the 5th or 7th years, about 500 kilograms and 700, 800 kilograms as the years go by. In the 10th year of the orchard, about 100, 110 kilograms of agricultural produce of walnuts in this case, and after that about 130 and 180 kilograms of walnuts. So what would they do with it? Would they sell it? Yes, they would sell the walnuts, and to sell them at a higher price. My mother-in-law would collect the kernel and would sell the kernel from the walnut for a better price. So they were trying to collect the kernel whole, because it was more expensive. It could be sold at a higher price than kernel that is broken, so to speak. So that's what they were doing throughout the entire winter. They would collect the kernel from inside the walnuts, and then they would sell the kernel at the market. Can you make an estimation of the funds that you received from your relatives of the procurements in 2012 and for the repayment of the loan in 2014, more or less? Can you provide an estimation of the amounts we are talking about? Well, right now, I mean, we would be we would always be given something. So even the thieves stole about 3,200 lei from her house, so she would rather give the money to us. She wouldn't keep too much money at home, and as soon as she would collect a little bit of a bigger amount, she would give us the money. So you can't be specific about the amount. No, I mean, it has been too long. It has been more than 10 tens of years ago. So too much time has passed in between. What about your savings in 2013? Can you make an estimation of that? You said that that was one of the sources to repay the loan. Can you make an estimation of the savings that you had? Well, it's been 10 years, and I cannot be very accurate, very precise now. I mean, it has been 10 years since then, and I have no idea. I cannot say what concrete amounts there could have been. Back then, at the initial evaluation, I did try to put down something on paper to make some calculations for 2019, and even then, I felt very confused, and I think I mixed everything all over again. Now that you provided me with these calculations, and I tried to follow those calculations that you provided, and I tried to get my own calculations sorted. I realized that the expenses for the construction of the house, I had not even factored that in. So I felt like I made a mess of all of that. But that's for 2019. Now we are talking about 2013. So you cannot make an estimation of that. No, it has been too much time has passed since then. It has been too long. Anything to add regarding this matter? No. Okay, next then, failure to declare financial contributions in the form of donations.
Tatiana, just hang on. I think, Nadia, you wanted to ask a question. Nadezhda, please go ahead. Yeah.
Oh, we can't hear her.
We can't hear you. Is the microphone on?
Yes.
It's still, yeah.
Sorry.
Yeah.
I have a question to issue one. Can I go ahead? Tatiana, is it okay? Da. Bună ziua, doamnă Cupcea. Eu am vrut doar să...
Good afternoon, Madam Cupcea. There's just one thing that I would like to clarify, to make sure that I got it right.
Susțineți că
You claim that support, that aid you were granted by a relative between 2003 and 2008. So you claim that that helped you make some savings of your own. Is that correct? Yes. In the initial evaluation, you stated that you were taking care, that you took care of the child of a close relative. That child was in your care. Yes. And that relative would transfer your funds for the maintenance of the child. Is that correct? Or is that what you said? Did I get it wrong? Or was the money for the maintenance of the child, or would they pay you for the service of taking care? They would give us food products. They would respond to other needs of ours. Well, then can you explain how foodstuffs helped you save money? What did you mean specifically? And we are talking now about 2012, 2013. So you have accumulated a particular amount on the basis of the fact that there were some maintenance expenses covered regarding the care of the child, and then you were able to save something. I mean that they were sending us foodstuffs, and so we didn't have to spend our own money from our own salaries to buy foodstuffs. That means that we had smaller expenses. So they would give you foodstuffs for a child, which was enough for an entire family. Yes, I mean, he was our nephew, and the mother-in-law would also pass on certain things. And now that you mentioned, they were sending you both money and foodstuffs. Yes. And you don't have any evidence to support this statement? No, because it has been a long time ago. Next, in the initial evaluation at the Supreme Court of Justice, you kept claiming that to repay the loan and to buy the property, you claimed that you used the savings from the pension that your father-in-law has granted you. Well, that was one of the sources. One of the sources. Is that correct? Yes. And it's only now that you've mentioned the salary of the mother-in-law and other sources as well. Could you explain what about the income of your parents-in-law? Would they give it all to you? Because now you seem to claim that they gave you more than the pension of the father-in-law alone.
I made that calculation that I sent after I received from the Ministry of Interior the certificate confirming the pensions. I drafted and I submitted the Commission a calculation that shows that only the pension of my father-in-law, without what they were selling out of the 3 hectares of land, without my mother-in-law's pension, only his pension was covering the population expenditure, consumption expenditure, and still saving was left, and not small savings. I showed the calculation. In 2007, the savings that could be only from the pension were 10,504 lei. So I made the calculation based or in the same way that the Commission does. No, Ms. Cupcea, I'm asking you something else. During the initial evaluation, you stated one thing, that the father-in-law gave a full pension to you, and that allowed you. Now you say that besides that pension, the parents-in-law were also giving you the mothers-in-law salary and pension and everything they sold? No, Miss Nadezhda, I cannot know exactly from what income. Were they putting the pension aside or what they were getting from selling produce? They had a budget of their family and they were sharing with us. I submitted to the commission the power of attorney that since starting with 2009, my husband was receiving the pension. That's what I'm asking. You said something during the initial evaluation at the Supreme Court, and now you are saying something new, and it is not clear what exactly you are stating. The contribution of the in-laws was bigger than the amount of the father-in-law pension. I'm saying it could be bigger. Now, 10 years later, I cannot give a concrete answer what the amount was. When we needed, they gave us. But from what sources, I cannot say specifically that it was only the pension or not, that it was only the pension that my husband was getting based on that power of attorney. He could go visit the parents and they would give him some more money. That was always, it was always like that. And where exactly did that come from? Well, your statements are very different, and that is just a couple of months past the previous statement. So it's difficult to understand what's your position. Thank you. I have no more questions. I only proved that based from the statement of facts from the commission, the questions from there were that they wouldn't have enough income to help us out too. So, and I proved, I attached documents, I obtained what the commission couldn't, meaning that unclear institution from state institutions, but I got an answer with concrete amounts. So I attached that information and I answered concretely that question that my in-laws had the financial possibility to help us too. And I showed that with calculations. But was that only from pension? Or did it also include the sale of produce or the pension of a mother-in-law? I don't know if that is that relevant. They had a joint budget. I just proved concretely that they could afford that. Okay, let's move to another topic. And that is non-declaration of financial contributions in the form of donations. In your answer to the statement of facts and serious doubts, you explained that you had complied with the legal regime regarding the declaration of assets and personal interests, and that the legislation of Moldova on declaration of assets and property has undergone several amendments over the years, and that the forms omitted sections on support aid contributions from close relatives like parents or adult children or credited. So therefore, the support aid or contributions from close relatives who are not family members could not be declared due to the lack of a legal framework, or they did not fall under the definition of income obtained together with family members as per the present law. You also quoted the definition of income as being any financial benefit regardless of the source of origin obtained by the declarant and the family members and cohabitant, both in country and abroad. Could you please explain what you meant by lack of sections? When you said that there was lack of sections in annual declarations regarding support aid contributions from close relatives, what did you mean when you made that statement? I analyzed the legislation on declaration on income on 9 pages, all the legislation, how it was adopted, I mean, starting July 2002 and until today. Do you want me to read out what I wrote? No, just what you meant. No, I made a summary too, please. When it comes to non-declaration of financial contributions received from parents during 2012 to 2014, and also serious doubts of the Commission in relation to the non-disclosure of cash savings for 2019 and non-declaration of financial contributions provided by my son in 2020, I'd like to explain that I followed the legal regime on declaration of assets and personal interests. Thus, the legislation of the Republic of Moldova regarding declaration of assets and property has been amended repeatedly over the years. On 19th of December 2011, Law number 181 was adopted, amending and supplementing some legal acts, and it came into force on 1st of March 2012, whereby, and according to Article 15, there was amended and supplemented law of 19th of July 2002. Thus, these regulations were to be applied in the declarations for 2012 that was to be filed in 2013. According to that law that amended other laws, the definitions under Article 2 were amended and supplemented, and new definitions were added, like family member, income, substantial difference, and they were the following. A family member was the spouse, minor child, and dependents. Parents were not my dependents. Then income was any bonus, addition, or increase in assets, regardless of a source of origin, expressed in pecuniary rights or in any other pecuniary benefit obtained by the declarant or her family members during the reference period, both in country and abroad. And the substantial difference was the difference between the acquired property and the obtained income exceeding at least 6 monthly salaries obtained during the declaration obtained during the declaration period by the declarant and his family members. The object of declaration was extended, and they supplemented Article 4 so that the subject of declaration, the declarant, was supposed to declare also income obtained together with family members during the declaration period. Let be movable and immovable goods of all types. C. Goods obtained through third parties or transferred them for a consideration. Then letter D is financial assets, that is banking accounts, investment funds, equivalent forms of savings and investment, bonds, checks, and so on, shares in the capital of companies, debts under the form debit, pledge, mortgage, guarantees issued for third parties. And then the declaration form was amended, and the way they were to be submitted, the body that was inspecting the declarations. So instead of a central commission for inspecting declarations of income and property, to the National Integrity Commission that was transformed into an independent body starting 1st of March 2012. The object of declaration continued to have no predictability because the declaration form omitted or lacked But it lacked sections about financial aid, contributions from relatives, credit debt towards family, towards the declarant and his family members. Therefore, the aid contributions from close relatives that are not family members could not be declared because the legal framework was missing, because they do not fall under the definition of income obtained together with family members as per the meaning of that law. These regulations were in force starting 1st of March 2012 until 1st of August 2016. On 17th of July 2016, law number 133 was approved on declaration of assets and personal interests, and it came into force on 1st of August 2016, except for Article 7, which is electronic submission of declarations, which entered into force on 1st of January 2018. Okay, that is clear. We are now talking about 2012 to 2014. Do you believe that these contributions can be considered as income or not? Yes, for the purposes of the law. Yes, as I said, they were not object of declaration because they were not income obtained together with family members under the meaning of the law that I just read. And I read those specific provisions. What was the declaration? Those letters from A through F. None of those letters, A, B, C, D, E, and F, were included. Yes, but in the income section, should they have been included or not? Not. Why? I said the object of declaration did not have predictability, continued not to have predictability. Okay, that is your position. The form, the declaration form, was missing sections on this. Do you have anything to add with respect to this matter? No. Are there any more questions on this issue? None, as it seems. Let's move on. The Commission has serious doubts about your compliance with the legal regime of declaration of assets and personal interest related to the non-disclosure of cash savings in the claimed amount of 484,000 lei in your 2019 annual declaration. The Commission also has serious doubts about non-disclosure in your 2020 annual declaration of a financial contribution from your son in the claimed amount of 150,000 lei used by your family to pay 3 substantial installments, total amount of 446,000 lei in 2020 to pay off the 540,000 lei loan contracted in 2018. If you wish, you can provide additional brief explanations to complement your written response provided to the Commission with respect to the statement of facts and the serious doubts. Please. So I started to speak about year 2019 with that calculation that I made wrong, and I saw the calculation in the statement of doubts as the Commission did it, and I saw the mistake that I made in my calculation. So by making that mistake, I got to the substantial savings. But actually, now, by making a calculation following the calculation that the Commission submitted to me in the statements of facts, I noticed that I did not include in expenses the cost for the building of a house, the 270,000 they cost for the construction of a house. And since I included only the population consumption expenditure, meaning that I included all of the income, but on on expenditure side, I only included the 89,000 for the reimbursement of the loan and 91,000 lei for population consumption expenditure. I made a mistake in calculations. That's the explanation. I did not have savings that were that substantial, that big, that were exceeding the amount provided for in the law that would have to be declared. Moreover, we were building the house and all our savings were being used for the construction of the house. Okay, on topic, in 2018, you received a 540,000 lei loan from a Moldovan bank to complete your house construction. By October 2020, you paid a significant part of the outstanding balance in the amount of 446,000. Payments were made in April, that was 182,000, September 100,000, and October 164,000 in 2020. Yes, the loan was fully repaid next year in June 2021. Now, during the initial evaluation, you explained that the funds you used to make the payments consisted of your husband's pension, his income as a lawyer, and family savings. During the resumed evaluation, the Commission provided you with the calculations according to which there were significant year-end cash balances during the years 2018 to 2020. So with respect to non-declaration of cash savings in 2019, you justified it by stating that when you were submitting declaration, your savings no longer exceeded 15 average monthly salaries, meaning on 30th of January 2020, because you purchased construction materials during the winter in order to get a better price. Now questions. Could you please clarify whether you had savings exceeding 15 average salaries per economy on 30th of January 2020, at the moment you submitted your 2019 annual declaration? No, I did not have savings exceeding the amount allowed, the 15 national average salaries that were not subject to declaration. I did not have such a big amount of savings. So, but please explain, why did not you declare your cash savings in your 2019 declaration? I did not have that much savings. Yes, is that the reason? Yes. I did not have that big savings that would have to be declared. Do you have anything to add? No. Are there any questions? Commission members, do you have any questions? No questions. And the last subject, non-declaration of a donation of 150,000 lei from your son in 2020. In the written communication with the Commission and at the hearing during the initial evaluation, you confirmed that you did not declare in your 2020 declaration the financial contribution from your son in the amount of 150,000 lei. With respect to this contribution, you explained during the resumed evaluation that even though the Commission categorizes them as donations, or that is income at that time, those amounts were not supposed to be declared. Moreover, were taken individually, each amount was not exceeding the amounts allowed by the law, and also the gifts received from family members, parents, brothers, sisters, or children were not supposed to be declared if the value of the gift did not exceed 10 national average salaries. During the resumed evaluation, you mentioned for the first time that the 150,000 lei amount was received from your son in 3 installments, in 3 parts, and you said that the value of each of these parts did not exceed the 10 monthly salaries and were not to be disclosed. This statement appears to be inconsistent with your previous statements that you made during the initial evaluation, namely that the amount of son's contribution for the repayment of a loan was 150,000 lei out of the 265,000 lei paid in September, October 2020. Questions. During the initial evaluation, you just mentioned that you received 150,000 lei in 2020 from your son. Is that right? Was it like this? I did not receive. We were taking it on our own when we needed. He was keeping his money with us all the time. And he allowed us, when needed, to take some of the money. And when I asked my husband, because he was one responsible for the loans, meaning that he was taking care to repay it, I even had no idea with what bank it was, what were the amounts. I was a guarantor, but I mean, I don't remember what bank office it was opened with, because he was the one to go and handle that. And when I asked him during the evaluation, when I had question rounds about those three big terms, 182,000 7th of April, on 100,000 on the 3rd of September, and 165,000 on in October. And I asked him, what's with this amount? How do I explain them? And he told me, I probably took from Elvis. He allowed us, and I was taking then I put it back and then taking it again. It wasn't a problem. The money was always at home, and with his consent, as he said, just take the money when you need, and when I need, I know that you will give it to me. No, wait, let's clarify. The amount, 150,000. How did he give it to you when he was in Moldova? Well, he was always coming home with money. So he came home and he gave you this amount in one time, one amount. The money was in his room all the time. When he was coming, I saw it in the materials that you have statements from border crossing by him. You have the information about how many times he crossed the border, how many times he came home. He always came with amounts of up to $10,000. I am speaking concretely about this amount. So the money was at home, and we took. In what year was that? When did he give that amount to you? The money were at home, Miss Tatiana. Every year. In 2018, 2019, he left in 2017. In 2018, 2019, 2020, he was at home twice. In 2021, he has been at home twice. Or maybe he was once in 2020 and then 3 times in 2021. Because I remember he was coming more often, 2 or 3 times per year. But what was the amount? In his room? Yes. What amount? I was not counting. 150,000. You declared 150,000. I'm telling you. Out of his money, we were taking money when we needed. And as I said, in April, I took what amounts? Altogether. But no, explain. It's in installments. You said you took kind of 3 tranches or installments. How much the first one and when? The second time, how much and when? The third time, the amount of and when? Can you tell that? I'm saying that my husband was handling that, but I know, like, looking at the dates when he was repaying the credit. In April, he probably took what amount? Probably around 50,000. That's what I'm saying. It was 50,000. Then in September, 50,000 again, and in October, 50,000 again. And that makes up 150,000. Do you insist on that it happened like that? Yes. It was in 3 tranches, and in 2020, the amount taken individually, if it wasn't exceeding 10 average salaries, it did not have to be declared. But why didn't you explain that during the initial evaluation? because I am in the state that I am, and I apologize for that.
Bine.
And back then it was
Puteți
even
ceva
more.
mai adăugător la acest subiect?
Could you
Aveți ce-
please, do you want to add anything to this topic? No. It's just the financial contributions from him, even if we look at them as donations, those amounts were not to be declared because individually taken, they did not exceed the 10,000. Probably she means salaries. 10 salaries, not 10,000. Yes, I apologize. 10 salaries. So those amounts did not have to be declared because individually taken, they were not exceeding the 87,160 lei. Altogether, according to the amendment of the law of 29th of October in 2021, that amended, that was law 130 of 7th of October 2021, that entered into force on 29th October 2021. After that, so that amendment provided that it had to, you had to declare if during a year the aggregated value was exceeding that amount, but in 2020 the law was still providing about individual amounts, and individually we had like the 50,000 parts that were not over the 87,000. And I am sorry, you asked me also why back then I did not provide clearer explanations. It was a short time. I really had little time, and well, I am in this condition and very limited time for all of the explanations, and
Bine, vă mulțumim. Aveți ce
well,
mai adăuga
thank
sau
you.
clarifica
Do you have
pe
anything
acest
to add
subiect sau
or
ați spus tot?
clarify on this topic, or did you
Tot
say
am
everything?
spus. Întrebări
Well, I said it all.
comisiei?
Do the commission members have any questions?
Oh, yeah.
No, I don't have any questions. Oh, thank you.
Okay, then let me see. Yeah. Since we have now come to the end of the hearing and the discussions we had with you, I would like to give you the opportunity to make a brief closing statement if you would like to do so at this very moment. Please, Ms. Cupcea, please go ahead if you would like to make a brief statement now.
I would like to thank you. That is everything that I wanted to say.
All right, thank you very much. With that,
Well, as I said previously, all the documents that I've attached, that I've sent, I felt certain that I had mitigated all the doubts, and I asked for this hearing on the basis of Article 4 of the regulation because I wanted to show that I was open for collaboration.
Thank you very much. With that, we come to the end of the hearing. I thank you, Mrs. Cupcea, for being with us this afternoon, providing answers to all the questions that we had. The Commission will now withdraw for the deliberations, and as we also did in the first instance, as much as possible, we will strive at delivering a decision within a month after the date of the hearing. I hereby declare this hearing closed. Thank you very much again for being with us this afternoon. Thank you.